Guess what? Your emails are private. Here's how the IRS uses digital evidence against taxpayers and what the Mukhi case reveals about email privacy, summonses, and criminal tax exposure. If you think your emails are private, think again. That may not be true. The truth here is the IRS doesn't need you to forward your messages to them to read them. In certain circumstances, they can legally obtain your emails from third parties. And if they do, they're going to use them against you in civil audits and criminal tax investigations. In recent cases, private emails have been some of the strongest evidence used to prove criminal intent. Today, I'll explain how the IRS gets your emails, what the Mukhi case changed going forward, and what you should do before digital evidence turns your case dangerous. Hi, I'm David W. Klossing. I'm a dual licensed tax attorney and CPA, and I have a master's degree in taxation. And for nearly 30 years, I defended taxpayers in high-risk audits, eggshell and reverse eggshell audits, and criminal tax investigations. Email evidence is now one of the IRS's most powerful tools to use against you, and most taxpayers don't realize how exposed they are. This is cutting-edge stuff. Here's why emails matter so much. Emails capture your intent. They show what you knew and when you knew it. And they also show what you plan to do. When the IRS wants to prove willfulness, they don't rely on spreadsheets alone anymore. They look for words like, let's move it off the books. Don't report this. Use cash for that. Or, we'll come back and fix that later. The bottom line is that one careless email can undo years of careful and legitimate tax planning and compliance. Here's how the IRS legally gets your emails. The IRS doesn't usually start out by asking you for emails. Instead, they'll issue legal demands, summonses, and subpoenas to third parties such as email providers, cloud storage platforms, employers, business partners, and most dangerously, your accountants and your tax preparers. And now lastly, IT administrators. Under long-standing law, if the IRS lawfully obtains emails from third parties, those communications can often be used against you, even if you never consented to them obtaining them. This is where many taxpayers misunderstand privacy rights. Note, in a civil audit, the IRS is required to inform you of what third parties they are approaching. In a criminal tax investigation, they are not. Let's discuss the Mukhi case and why this matters. In the Mukhi case, the government relied on emails obtained from third parties to support its position. The court reaffirmed a key principle. When emails are shared with or stored with third parties, your expectation of privacy in them is significantly reduced. That means emails you assume are private may not be protected once they pass through someone else's system. This is especially dangerous in tax cases where emails often involve bookkeepers, tax preparers, partners, and advisors. There's a difference in civil audits versus criminal investigations here. In a civil audit, email evidence may be used to expand the scope of an audit, like adding prior years to the situation, to assess a 75% civil fraud penalty, and to disallow deductions. And the scary part here is they can use them to convert a civil audit into a criminal tax investigation. But in a criminal tax investigation, emails become intent evidence. Listen, willful intent is often the hardest element of a tax crime for the federal government to prove. They can use email to show knowledge, concealment, planning, coordination. Once criminal intent is alleged out of a civil audit, the stakes change completely. Here's some common email mistakes that can create exposure. The IRS frequently uses emails that include informal explanations of tax positions, speculation about what the IRS will ultimately see or do, instructions to alter records, casual admissions of mistakes, discussions about hiding income, or attempts to backdate documents. Even joking language in your emails can be taken out of context and used as evidence against you. Remember, emails don't have tone, they only have words. Here's what emails the IRS can't use. There are limits. Emails can be protected by attorney-client privilege and attorney work product doctrine, and generally shielded in that manner. One reason why you might want to hire an attorney in an audit, not your original preparer, if privilege is properly established and preserved. But emails with your accountants, your bookkeepers, or your consultants are not privileged, anybody that's a non-attorney. And once an email chain includes a non-privileged party, protections can be lost. This is why structure matters. Here's how we protect clients from email exposure. When we step in early, we take over all communications with the IRS. We secure attorney-client privilege. We assess your digital exposure. We stop unprotected email traffic immediately. We coordinate responses through counsel. We prepare clients for document production, and we limit the audit's expansion, both civilly and criminally, and to other tax years. We prevent civil cases from becoming criminal. Listen, early legal intervention often determines whether emails become evidence in the first place or remain protected. So in closing, your emails may already exist in a system that you don't control. And once the IRS gets them, you can't get them back. And if you're facing an audit, or if you're worried that emails or digital records could be used against you, whatever you do, don't wait. Call the tax law offices of David W. Klossing today at 800-681-1295 or visit klossingandassociates.com. Do that to schedule a confidential, reduced rate initial consultation today. We'll help you protect your communications. We're going to control your exposure. And whatever we do, we're going to keep a civil audit from turning into a criminal one. Thank you.